still on to this morning on ITV. Up next is our second discussion segment, and we are looking at impeachment in Nigeria. In our short history, democratic history, you want to say between 1999 and now, one significant occurrence was that of August 13, 2002, where the House of Representatives passed a resolution asking the president to resign within 14 days or be impeached. The motion catalogued presidential offenses, which to the House amounted to grave misconduct. As soon as the political development became public knowledge, the presidency swung into action, and then there were solidarity marches to presidential villa to arrange to support the president's cause. We know what happened. Such words like nascent democracy, anti-democrats, people trying to truncate democracy were thrown into the fore, and hysterical reactions were all over the place. Eventually, the president survived it and survived yet another tenure. Today, we are looking at all of that. Why should anybody want to impeach anybody in power? The governor, deputy governor, speaker, or the president himself? Only last week, we saw President Goodluck Jonathan talk to speakers from various states in the country, telling them to be careful as they use the clause in the Constitution intended to be for impeachment. Today I have with me on set to discuss impeachment in Nigeria, Chief Nkerenwem Akpan is a lawyer and a human rights activist. Good morning, sir.
Good morning, thank you.
So, impeachment in Nigeria, what is the position of the law?
Position of the law is clear. It's clear. If you have a man voted into office, he takes an oath of office, an oath of allegiance, and an oath of office. Allegiance to the Constitution. Allegiance to protect and defend the Constitution. So if the man goes haywire and starts to flout the very provisions he's taken an oath to defend, then those will be deemed to be gross misconduct, and then they are impeachable offenses. If you look at section 143 of the Constitution, 143 with respect to removal of the president, and 188 with respect to removal of the governors and deputy governors, you see there's some critical milestones, some critical steps to be taken before you could those provisions becomes effective, so to speak. Now, let's look at the removal of the president and vice president, 143. So paragraph 1 to 11 of the Constitution, 1999 Constitution. So the 143, so paragraph 1 is clear. The president can be removed. The president and vice president can be removed. But the steps as set out there on the other one, there would have been a petition, which petition will include some serious allegations by at least 1/3 of the members of both houses of parliament, the Senate, House of Representatives. So you are going to have 1/3 of the House of Representatives come up with a petition alleging that the president or vice president committed XYZ offense. You're also going to have 1/3, members of the Senate also come up with such a petition. So you're going to have two, petitions signed by, even it's going to be one petition signed by at least 1/3 of the members of both houses. Now, when that gets to the Senate President, within 7 days of his receipt of those provisions, of those petitions, now makes a copy of each available to every member of the National Assembly, the Senate, House of Reps, and also to the man who is being accused, whether the president or his vice. Now, upon receipt of those allegations, the man who is being accused, whether the president or the vice president, has 14 days to respond to those allegations. Now, whether or not he responds is not an issue. Within that period, the Senate President, both houses of National Assembly, now will, by simple resolution of 2/3 majority, decide whether or not the allegations on the face of it are even investigable offenses, whether there's need for them, those allegations to be investigated. Now, if by 2/3 majority of both houses, the National Assembly comes to the conclusion that those offenses ought to be investigated, now the President of the Senate will be obligated within 7 days to set up to call on the Chief Justice of Nigeria to set up a panel of 7 men of integrity who ought not to be members of any political party, ought not to be ministers or members of permanent secretaries or people in public service. People of independent-minded, people of integrity, 7-man panel to be set up by the Chief Justice of Nigeria. These ones will be given 90 days to submit their report. Now, if at the end of those investigations, the report comes and it's negative, that's the end of the matter.
If it's positive.
Now, if it's positive, if the allegations are proven, then both houses, Senate and House of Representatives, by 2/3 majority, by a resolution, adopt the report. Now, from the date and time that report is adopted, the president or vice president cease to hold office.
Okay.
Now, if you look at, there are critical milestones and you must follow them slavishly. Now, but it's a danger in all of this.
Before you go to that,
yes.
Is there at any point, can this process be stopped at any point? Or once it is started, you will have to go through?
No, once it starts, goes the whole hog. Because it's statutory, the Constitution is supreme. If you look at section 1, subparagraph 3 of the Constitution,
once you start the impeachment process, you don't abort it.
You can't abort it halfway. There's no provision for abortion, except, at the point, there are 2 points it could be aborted. Well, aborted is a matter of choice, if you like to use the word abort. But I think the Constitution itself decides that it could be aborted at that point. For instance, 1, if at the point the report is sent to each member of the National Assembly and they call for vote, and they couldn't get to 2/3 majority of both houses of Parliament, at that end it dies.
Even though the allegations are strong and true, are verified.
That's your word against the National Assembly. They said there's no need to investigate, so that's the end of the matter. But if they say that there's need to go further, then the Senate President is obligated under the Constitution to call on the Chief Justice of Nigeria to set up that panel. Again, where it can be aborted is where the panel itself, after 3 months, within 3 months, comes out with a report that is negative, that this is frivolous, there's nothing in here. It ends there too naturally.
Yeah. What about if they come with a positive result and we cannot get 2/3 majority of the House to adopt that report?
Now they come up with a 2/3 majority. So you said that the report becomes positive. Yes. You can be sure that you're going to have a 2/3. I mean, it's a matter of course.
Yeah, if between in those 90 days anything can happen.
No, 90 days for them to come with a report.
Yes, by the time they come up with a report that says this person has been indicted, and then the National Assembly has gone through the
National Assembly has they have no power at that point anymore. Okay. They simply adopts the report of the panel. If the panel says, look, this man has flouted the Constitution, the National Assembly is made. If you look at the National Assembly, is set up to make laws for the good, to the peace, order, and good government. For the peace, order, and good government. National Assembly set up this panel in the first place. They started the process. So why would they flout the report of the panel?
Okay. Yeah, let's look at something. What would you say is the real meaning of the term impeach? Now, a lot of people refer to it as simply to remove from office. Should it not be more sacred or more important to us, for instance, like to accuse a public official before an appropriate tribunal of misconduct in office? Now, we don't go to that point.
The meaning of the word impeach has nothing to do with removal. If I say I could impeach your character, I could impeach your testimony, it simply means I could discredit your testimony, I could discredit your character. Impeach has nothing to do with, it's not the same thing as removal. In the whole history of the United States, the system which we so slavishly follow, only one president was quote unquote impeached. That was Bill Clinton by the House of Representatives. He was impeached for the Monica Lewinsky affair. That he lied. I mean, now so people, if you look at section 143, 144, 145, and then 188 of the Constitution, 143 relates to, impeachment, this sort of removal. Okay. 144 relates to issues of ill health, like we had sadly the Yaradua scenario. 145 relates to mental, incapacity when the president maybe is going on leave, on vacation, or transmits a letter to to the National Assembly that, look, I'm unable to continue. Now, 188 relates to the governors and their deputies. In all of these provisions, there are critical milestones, there are critical steps to be taken. And if you miss any of the steps, then the court can come in and intervene. Remember that if you look at section 143, subparagraph 10, no court of law has the right to question the impeachment process so long as you follow the process. Now, it is when you miss the process that the court will invoke their powers under section 6, subparagraph 6A and B to investigate to see whether you have, in fact, complied with the Constitution. Now, there's a danger in all of this. Danger is this. If you look at section 143, subparagraph 11, the interpretation section, it says, tries to define what are gross misconduct. It says that gross misconduct will amount to any, violation of the Constitution. I have no problem with that. But there's a second arm to that arrangement, which says any other thing which, in the opinion of the National Assembly, will amount to gross misconduct. You can imagine that if the president decides to take a second wife, some people could feel that it's an impeachable offense. The president, worship in a particular church, or suddenly goes to mosque on Friday, some people could think they are impeachable offenses. Or decided to go on vacation to a country that some people feel so strongly about, say in Afghanistan, or in one country that we don't have, we're having some crisis with. So it is that second leg of the definition of gross misconduct that gives me a lot of worry.
Yeah, but does the court not have a role to play in the interpretation of what is gross misconduct?
To the extent that it is left open, the court will have little power. Now, the court, of course, will know when the Constitution has been flouted. If the president neglects or abuses any of the sections of the Constitution, then it will be clear. And that is clear that, look, by section 143, subparagraph 11, you have violated section A, B, C of the Constitution. The court will interpret. That's straightforward.
Yeah, but the second part is what we are looking at.
Second part is critical.
And I want you to answer it in this context. Now, is this just a fear that exists that there is likelihood of an abuse, or if you check our history, we have abused this second leg?
90% of the time, we've abused the second leg. 90%. In fact, if you look at all the impeachment, let's go back to 1979 or 80, 81. Balarabe Musa in Kaduna State was removed as governor. In fact, it was the first case of impeachment in the country. What was that reason that Abdul Qadir Balarabe Musa was impeached? Go and look at the records. It was politically motivated.
They had reasons.
I mean, that's their reason. Politically motivated. Every impeachment move in this country has been politically motivated. And because people rely...
There are actions by politicians. I have a problem with the fact that we say political motivations. Everything in Nigeria looks like politics now. We cannot differentiate our real life from what is politics.
The Constitution is the supreme law of the land. The makers of our Constitution knew what they were doing when they said, beside violation of the Constitution, they should leave an opening for any other conduct not envisaged.
Okay, so how can we stop
Give me a second.
How can we stop all of this because of time?
Now, the president took an oath to defend and protect the Constitution. He should stand by it. Every member of the National Assembly took an oath also to defend the Constitution. He should stand by. We should take politics. Which is difficult. I mean, I must concede, out of the impeachment clause. Because it is the one clause that if abused, if you go back to the Yaradua scenario, this was ill health. This man was ill. Everybody prayed for him to get well. I did. Everybody did. Because I know he was a honest man. But it was the will of God that he should go. And the law is clear that in such scenarios, we should look at section 144, 145 of the Constitution. Yet people were playing games with it. People were playing games, going around in circles. How much more such a massive political swerve
are ready? Maybe witnesses have been imported or even brought from very far places to the court. Does it bother you how long it takes for one case from start to finish to be exhausted in Nigeria? That's what we're looking at. Delay in judicial processes. Why? And what's the way forward? I have with me in the studio Barrister Akpan, Nkeri Akpan. Good morning, sir.
Good morning. Good to see you.
Well done, sir. So you're all looking dressed up for the courts.
Yes, certainly.
Yeah, but the court processes. We talked about Nigeria's judicial processes 50 years so far, 2 weeks ago. But today we are forced to come back to it again to look at the entire process itself, especially the issue of delay. Why is it so in the courts?
You will have to look at delays from certain categories. You will look at delays from those are called the administrative delays. Then you look at delays from statutory point of view, statutory delays. Then you look at delays that are procedural in nature. And then finally, those are called crazy delays, those bordering on technicalities. And now we're going to compartmentalize and put delays in the different compartments. You notice that the most worrisome will be the last genre I mentioned a while ago.
Let's start from the
Excellent.
administrative delays.
Administrative delays. Administrative delays are those delays that are caused by, one, there seem to be too many cases, and the judges and the courts are just too few to handle them. Second,
what about the recent appointment of judges?
No, you will never going to have enough judges, because as society develops, as people start to go into businesses, you're going to have interaction. You're going to have people disagree. And it's when people disagree that they go to court. And 90% of the time, people are going to disagree. Even close friends, even family members go into business. Now, let's go back to the administrative delays. You have a scenario where there is so much case filed before the chief judge. You need to assign them to the various judges. Nobody else does it. The law makes it clear he is the person who's going to assign these cases to the rest of the judges. Now, those fall within administrative delays. Now, the second and most worrisome aspect of the administrative delays are respect to the secretaries, the registrars, and the clerks of court. You have this problem of arranging for a process. Say, for instance, you go in an appeal and you want a record of proceedings. You want a CTC of a judgment or the order or the ruling of the court to appeal against. And sometimes you only have 14 days. But believe me, you may not get that ruling in 3 months. And I've been involved in a matter that even after the judge has signed the ruling, the registrar hides it in his drawer. Do you know why? He's expecting you to come and see him. See him is in inverted commas.
That's not corruption.
Now, the proper thing would have been for him, once the judge signs the order, to put it in the files so he can go and get a copy. But he puts it in his drawer. So you have to go see him.
In other words, lawyers they normally go to see.
No, you must. When they say make arrangement for ruling, you go ask them to type it. Sometimes they don't have the type. They don't have the facility to type. You may assist by way of, maybe sometimes we don't have paper. Too many outrageous reasons. Now, away from the administrative delays, you have the statutory delays. Statutory delays will fall the categories that, for instance, a judge has spent 3.5, 4 years handling a matter. And it so happens that he's being elevated to the Court of Appeal. Or, God forbid, well, it does happen, the judge dies. You're going to have that matter started de novo. Afresh. De novo simply means afresh, before another judge. So, this judge has spent time. Witnesses have been summoned, the testimony is taken, they have been cross-examined and re-examined, and the man adjourns for judgment. Suddenly he's promoted to the Court of Appeal. Or he's ill, or something happened, or God forbid that the judge will be dismissed. He's dismissed or something, anything. That matter is transferred to another judge and it is to be begun de novo. Okay. Now, you don't have the procedural delays. Procedural delays in the sense that, well, if I'm in court and you serve me a process, I'm entitled to at least 24, 48 hours. And even if I have the ability and the intelligence to handle the matter there and then, I say, well, I'm entitled to my 48 hours. And the judge has no option because it's statutory. I'm entitled procedurally to 48 hours to respond to your application, at least. Sometimes I have 14 days or 7 days, and I will insist on my 7 days. You see the point? So those has to do with procedure. Then you have the technical delays. This makes me sad. Technical delays are that, it makes me sad because you actually have to be a very intelligent lawyer to be able to rely on technicalities. True. So the intelligence, the wisdom of our smart lawyers, who would have been translated into some very good, decent judgments, have been used negatively. I'll give you an instance. A man looks at the matter and this matter is not going anywhere. He says to himself, he raises all manner of applications, and you oppose him. The judge rules. He picks the rule and goes on appeal. And for interlocutory ruling, he has 14 days to go on appeal. Even after that, he can come by way of leave. For extension of time, we don't wish to appeal. The matter goes on appeal. The average time of any appeal in the Court of Appeal is about 2 years, 2.5 years.
And then you have not started discussing the substantive.
The matter is you're talking about maybe jurisdiction, a threshold matter of jurisdiction. To threshold, you said I have to decide on jurisdiction. You have to move into the man go into the trial.
Yeah, but sometimes lawyers also do that. You have a lawyer, for instance. I was in the court the other day, and there was a lawyer who was to file a very important case involving very senior members of the National Assembly, and then instead of going to a federal high court, decided to go to an Abuja high court. And somebody said,
I mean, it happens all the time. And sometimes I begin to wonder the motive behind some of these things. Now, when people say that some trials are politically motivated, I tend to disagree generally. But there will be sometimes I'm bound to tilt towards agreeing, because if you have a senior lawyer who knows that this matter ought to be at the FCT High Court and he goes to the Federal High Court, he knows that this matter ought to be begun by this particular law and he uses a wrong law. I ask myself, it could only be sabotage.
Yeah, so it's also a delay not only on the part of the bench.
Now those are the technical, those fall within technical delays, because now generally, if you begin to compartmentalize, you begin to talk about delays in the various categories, you'll be looking at technicalities falling between, cutting across all of these areas. You could raise a technical delay in critical, whether delay comes. Okay, all right, I can say yes, I have applied for a record of proceedings. It's not been given to me. And until I have that, which is my right, I cannot file an appeal. Sometimes there's connivance. Sometimes there's so many things, weird things happen. But bottom line is this. The maxim that delay defeats equity and that justice delayed is justice denied has to be balanced with the maxim that you do not sacrifice justice on the altar of expediency.
Yeah, but now, at what point would you say a matter is expedient, and at what point should you say a matter is delayed?
If a man is entitled to 7 days, we don't wish to respond to, say, a reply, to make his reply on point of law, and he insists on the 7 days, why will you force him to abridge time?
Yeah, but even if, for instance, you need 7 days to make an appeal, and all the
14 days or 90 days in a final judgment.
Instance, 14 days, let's take 14 days, for instance.
Yes.
And then within those 14 days, you don't have the support or assistance of the administrative staff in a particular court. What would you do?
The law is clear. You wait until you have the ruling or the judgment you want to appeal against, the order you want to contest and appeal, and then you get it ultimately. Then you go to the Court of Appeal, because usually
if you don't get it properly, you get it by seeing the registrar somehow.
No, when I say singing, you're not looking at bribery in the true sense of the word. This man tells you in honor that we don't have a typewriter. Our typewriter has broken down. Okay. We need to go and type this outside.
Oh, he tells you I am
closed
for the day.
No, we don't, and we don't have paper. Until they buy printing paper, we cannot print. So and it's not your duty to go buy paper. But you have a ream of paper in your car. And you're like, print this thing out, take it to the judge, let him vet. Because the judge has to go through the ruling, make corrections, and send it back to the registrar for the final copy. And the judge has to sign the ruling. Then you certify it. But let's even go back to the procedural delays I mentioned a while ago. Rules of procedure are clear. If I have, say, in a final address, if I'm given 14 days or 21 days to file my final address, and 14 days for the respondent to reply, and another 7 days for us, maybe for me to make my reply on point of a law, if any, it is not compulsory that I should wait until I should take all my time. Sometimes parties can, with leave of court, abridge time. Parties can come together and abridge the time. What parties cannot do is to meet and extend time. You need leave of court to extend time. Now, but the court can make an order. Look, in the interest of justice, say elections are next week. We need an order this week. Then the parties can come to look, we need this order. So we can abridge, let's abridge time we require to do some of these things. And matter, everybody goes home happy.
Yes, sir. Well, what would you say about the effect of such delays on general decisions to be made by other sectors, and other departments in society? Let's take a very recent case, for instance, the one involving the Constitution Amendment, National Assembly, and a very senior lawyer. He had gone to court to seek an injunction, for instance, stopping the National Assembly from carrying out further actions on the amendment of the Constitution, even though the whole country thinks that we need the amendment forthwith. What would you describe such order?
No, I would say that as a citizen, every citizen has a right to go to court. If you look at section 6, sub 6, paragraph A, 1, 2, up to, every citizen has a right to go to court to contest an issue bordering national good.
Yeah, but what kind of order, for instance, should be sought if you
Now,
know, and when you know that the nation is faced with the time constraint requiring us to amend the Constitution so that we can go ahead with elections, will it not be better to go ahead with the case rather than tell the judge, for instance, to stop the National Assembly from continuing with the process of amending the Constitution?
No, so long as the National Assembly complies with section, I think 8, 9, and 10 of the Constitution, 8 and 9 particularly, with respect to amendment of the Constitution, if those procedures laid down are complied with, I'm not sure that the judiciary can intervene. But you see, if a man raises an issue of law, that the Constitution itself has been flouted, then the courts must intervene to protect the law and the Constitution. Because the National Assembly is not above the law. They are also subservient, so to speak. They are also regulated by the laws they make. Now, if the law requires a two-third majority of all the various states of the various state houses of assembly to assent to a proposed amendment, and this has not happened, it's a good ground for somebody to go to court and challenge it. My worry will be frivolous, suits. Those that, like you and I know, that will look like these ones are politically motivated. But they are suits all the same, and they require the full attention of the court. And the procedures and the rules of evidence are clear. What to file and what not to file.
I did ask a question. One of the causes of such delays also, you did say, is the number of cases before these judges, so many of them. And to a very serious point, somebody had argued here a few days ago that there are so many cases before the judge that are deemed to be cases that are meant to waste the time of the court. Now, is it not fair, for instance, if some form of penalty is attached to such cases, if a case is deemed to see as wasting the time of court, don't you think there should be some form of punishment to deter such delays?
Well, if you say the court list is clogged by frivolous suits,
no,
now who
decides?
Say
there were so many cases.
Yes. What I'm saying is this: you do have two. Sometimes you have a judge that has 15 rulings pending in his case file. 15 rulings, okay. And he has to take his time, get the records, get the authorities, put these rulings down, and deliver them. So sometimes, what have a scenario where a judge has even been transferred. You see, comes in to write rulings because already, these ones were pending before him, and it amount to even further delay to transfer at that stage to a new judge.
Yeah. Well, what about the case of frivolous? If the case is discovered to be intended to waste the time of the court,
if a lawsuit is brought in that is deemed, who decides whether a lawsuit is frivolous? If the judge decided that this matter is frivolous and strikes it out, the man goes on appeal, and the appellate court says no, there's some merit, sends back for retrial. So sometimes it's even more time wasting. Not to allow us to be decided on the merit.
If we decide, for instance, that the case has no merit. Now, if in the end analysis it is agreed that this case has no merit, instead of merely striking it out, should there not be some form of sanction to the one who comes to waste the time?
Yeah, there's provision for costs. We do have provision for costs.
Yeah, is that enough?
That's the process all over the world.
Yeah.
You can't send a man to the gallows for bringing a lawsuit. You can't sentence him to death because he filed the matter in court and lost.
Or wasted the time of the court.
The man goes on appeal up to the Supreme Court, and after 7 years, he gets a judgment.
Okay. So,
Or he's sent back for a retrial.
so let's look at something.
On its merits.
This is 2010.
Yes.
And for some people in the last 15 years, computers have moved into the courts. But here we are, our judges still writing their judgments, their rulings in longhand. What would you say about
Do you know each time I go back and watch the O.J. Simpson trial and how everything was computerized, I fall sick about us. This is probably the only country in the world that we see the judges see right in longhand. That makes me sick. Makes me sick. Because we do have recording devices in all the courts. I do see them. In the FCT, we have recording devices, with microphones, and all of that. We have computers, and they're just covered. They're not being put to use.
Probably the judges are not very compliant.
No, I'm not sure it's about the judges. It's about the rules. It's about the rules itself. Because the judges are statutorily empowered or obligated to write down about everything that makes sense. They record the witnesses verbatim. They record the evidence verbatim. It is their ruling that even in their ruling they have to capture both sides of the divide, and then analyze the evidence, both sides of the divide, and then come to a decision one way or the other. So I think it's about time. I think about time we move to the computer age.
Yeah, you don't think we're a little late?
Some 30 years after others have done so.
Yes, and somebody did say if you achieve at 50 what you are supposed to have achieved at 20, you're not a hero. Yeah, but what steps are we taking? Are we going there anyway?
My calculation has been like this. If you have a country that is 50 years old and the legislature has nothing to celebrate, the executive has nothing to celebrate, we should at least concede the fact that the judiciary at least have something to celebrate. The judiciary is the only arm of government that has anything to celebrate. What are we celebrating in the executive? Leadership, corruption, fraud.
Judiciary, sir.
We've had some of the soundest justices in the world. If you take a man like late Justice Odoma, he was transferred. He left here and become Chief Justice of Uganda at some point. Some our justices have gone to the Hague. That's me liars. These ones have become a role model all over the world. In fact, we still have Justice Odoma's judgment, applied in the House of Lords.
So are you aware that they just stripped one of our former ministers of justice and a senior advocate of Nigeria with his title?
Yes, I am. I heard it in the papers.
Yeah, that's something to celebrate.
Well, if you ask for my legal opinion, I will say that the privilege committee that becoming a senior advocate is not a matter of right. It's a matter of privilege.
It's an honor, sir.
It's a privilege to be a senior advocate of Nigeria, sit in a bar, dress in silk, and takes a matter out of turn and all of that. Now, the man who gives that privilege has the right to take it away.
Yes.
The man somebody gives you a privilege, he has the right to look at you again and say, look, maybe you're not deserving of the privilege I gave to you, and take it back.
Now, is that not fault in the judiciary? Somebody of such esteem would become a minister.
That's nothing to do with the judiciary. This is the bar now.
Okay.
The Attorney General is on this side. Now, but it's a tragedy. The justice delivery system. The former Attorney General will be stripped of those illustrious ropes, and I would like to leave it at that.
Okay. So, can we ever get to stop delays in our courts?
Maybe we cannot stop it outright. As maybe tomorrow. We can achieve results if we move to the computer age that the rest of the world has done. We can achieve results if some of our senior colleagues stop sending their juniors to go to court merely to take debts. We can achieve results when people stop bringing frivolous applications. We can achieve results when you don't need to wait and take your 90 days to go and appeal in final judgment. You don't need to wait to take your full 14 days. Parties can come by consent. I have applied to court to have the time abridged. That way, you have, we have made some strategic and critical deadlines.
Okay. Yes, I understand you have to be in court this
Oh,
morning.
definitely.
We must thank you very much for coming. We have to cut this.
Pleasure is
discussion
mine.
here. Thank you. I wish you
Pleasure
luck
is mine.
with your case.
Thank you so very much.
That's the much we can take on this segment. We've been talking on delay in the justice procedure in Nigeria. We hope also that our cases will be shorter and the procedures also and the processes will be shorter. We've been talking with Barrister Akpan Nkere Onwem. He's a lawyer and a human rights activist. We'll take another break now. When we return, our news report segment will be up.